Hello friends, today I am talking about very important aspect of the CPC जो बहुत ही ज़रूरी है। उसके लिए लिमिटेशन क्या होते हैं, उन सारी चीज़ों के बारे में जानने वाले हैं। वो टॉपिक है अबेटमेंट ऑफ सूट, अबेटमेंट ऑफ अपील। माय फोकस इज ऑन द सिविल प्रोसीडिंग्स, नॉट ऑन द क्रिमिनल प्रोसीडिंग्स। Insofar as criminal proceedings is concerned, that if an accused person dies, the proceedings as against him stand abated. Means there will not be prosecution against that person who is facing criminal trial. उसी प्रकार अगर किसी आरोपी के खिलाफ स्टेट गवर्नमेंट हो या फिर कोई भी प्रोसिक्यूशन एजेंसी हो, इन्होंने अपील की है and that appeal is pending and during pendency of that appeal he dies, that appeal stands abated as against deceased accused. लेकिन कहीं कहीं ऐसा भी होता है जबकि appellant is the accused, he was convicted by the trial court, therefore that accused person has filed an appeal, he dies. Whether it can be continued, it can be subject to certain conditions. But today's topic is in respect of civil proceedings. You know that a party who approaches to the court, who files the suit, he is called the plaintiff. जिनके खिलाफ सूट फाइल किया जाता है उसको डिफेंडेंट कहते हैं। दोस्तों, आपको मालूम है ड्यूरिंग द पेंडेंसी ऑफ द सूट or in case of appeal, if either of the party dies, then what will happen? Whether the case will be closed, whether it will be dismissed, or whether there will be any order. इसके लिए आज हम जानेंगे। तो दोस्तों, the provisions for bringing legal heirs, bringing legal representatives on record are contained in Order 22 of the CPC. Order 22, please bear in mind. And the right word is not the legal heirs, but it is legal representatives. Legal representatives. I am repeating. If plaintiff files suit, he dies. Defendant is alive. There was sole plaintiff, he dies. The provision, rule number 1 of the Order 22 says no abatement of suit if right to sue survives. No abatement of suit if right to sue survives. If the cause of action is there and the right is to sue is already in existence, it is surviving, then the suit will not be abated. So is the case of the appeal. इसी प्रकार अगर डिफेंडेंट गुजर जाते हैं, if the defendant dies, then suit will be continued as against the person who are representing the estate of that defendant. So rule 2, 3 and 4 of Order 22 are very much clear. I am not taking you through those rules, just I am pointing out which are the rules relevant for the purpose of bringing legal representatives on record. Rule 2, 3 and 4 of Order 22. What is the limitation? Why I am preparing this video? I have seen on number of occasions that an application is moved before the Honorable Court for bringing legal heirs on record, and the Honorable Judge always asks to the students, the newly entered professional advocate, as to under which provision this application is moved. What is the limitation for bringing legal heirs? In legal circle we call it legal heirs, but my friend, the right word is legal representatives. Legal heirs may be legal representatives. I am repeating, legal heirs may be legal representatives, but not all legal representatives are legal heirs. and therefore the appropriate word is legal representatives who are representing the estate. Then who are the legal representatives? You will have to see definition clause of the CPC. Section 2(11), which provides the definition of legal representatives, means a person who represents the estate of deceased or who intermediates the estate of disease. He is called legal representative. For example, if the plaintiff dies leaving behind only one son, son is his legal heir, he is a legal heir. At the same time, he is representing the estate of his father, he is a legal representative. Another example, my friend, if that plaintiff dies and in respect of the subject matter, he had executed the will in favor of one beggar. Out of love and affection, he wanted to gift his bequeath his property to one beggar. So he has bequeathed his property in the name of one beggar. Beggar I am talking about. He is the legal representative because now he will be representing the estate of that deceased plaintiff. And therefore, who is representing the estate? He is necessary to be made as a party, to be brought on record by amending the plaint or the memo of appeal, as the case may be. Then, what is the limitation for bringing legal representative on record? Where is the provision? Order 22, Rule 1, 2, 3, 4 provide for the manner in which the applications are to be moved, the effect of the death of either of the parties, but the limitation is provided in the Limitation Act. Article 120 of the Limitation Act provides the prescribed period for bringing legal representatives on record is 90 days. 90 days is the limitation period provided by the Limitation Act for bringing legal heirs on record. So, if someone dies, either of the plaintiff or the defendant or the respondent or the appellant, as the case may be, dies, then one has to apply within 90 days for bringing his legal representatives on record. And if legal representatives are not brought on record within 90 days, then what will happen? On 91st day of his death, the suit or the appeal, as the case may be, will stand abated. So, suit or appeal will abate as against deceased person, deceased party. Then what is the remedy? My friend, if either of the parties fail to bring on record the legal representatives within 90 days, and after the 90 days, stipulated time is 60 days for setting aside abatement. Article 120 provides, I am repeating, my friend, there is a reason for this. Article 120 provides 90 days for bringing legal representatives on record, and on 91st day, if they are not brought on record, the suit or the appeal stands abated, and one can file an application for setting aside abatement within 60 days. Article 121 of the Limitation Act. Article 121 provides 60 days for bringing legal heirs on, for setting aside the abatement. What if the application is not moved within 60 days for setting aside abatement? Then, my friend, Section 5 of the Limitation Act will come into picture for condonation of delay in filing an application for bringing legal representatives on record and for setting aside abatement. So, now see technically, if one of the party dies and right to sue survives, then the parties' legal representatives are to be brought on record within 90 days. So, simpliciter an application is required for bringing legal representatives on record. no application for setting aside abatement, no application for continuation of delay. But if within 90 days it has not been done, then two applications will be required. Number one, application for bringing legal representatives on record. Other one, an application for setting aside abatement, because as I told you, on 91st day, the suit or the appeal, as the case may be, stands abated, and therefore an application for setting aside abatement. And even after expiry of 60 days, if no application is moved for setting aside abatement, then Section 5 of the Limitation Act, you will have to seek the condonation of delay in filing these two prayers, two applications. One, bringing legal representatives on record. Other one is setting aside abatement. And third application is for condonation of delay. You will have to satisfy the Honorable Court as to why there has been delay in moving these applications. There can be three applications, or one can make prayer as per the practice prevailing in that court. But you will have to, because why three applications are required? Because you will have to pay the court fees on each application. Sometimes many times we see that three prayers are made in one application, but it depends on the Honorable Court whether to entertain one application or three applications. So this was the topic of today's discussion. Why I have chosen to discuss this topic today, because I have seen on number of occasions that these applications are day in and day out filed in the Honorable Court, and the Honorable Judges, they particularly ask under which provision it is filed, what is the limitation, etc. And therefore I have chosen today's topic. I am hopeful that it may be useful for the budding and new lawyers. इसी प्रकार हमारे वीडियो देखने के लिए हमारे चैनल को सब्सक्राइब करना ना भूलें मेरे दोस्तों. थैंक यू फॉर वॉचिंग दिस वीडियो. जय हिंद. धन्यवाद.